Hey, what's up, my YouTube fam? I'm back. This is Larry with the Best Credit Repair channel. Today, we're going to get in education mode, and I'm going to cover 1681I, the procedures in case of disputed. I think a lot of people don't really understand, uh, the actual procedures uh, to increase your chance for get deletions. There are certain things that the credit bureaus must do. We take shortcuts. We don't follow. We listen to people that haven't read the section, don't understand the section, or take a little bit out of the section, and then don't follow through with the process. This process, and as I go over them, when you're going through that dispute process for inaccurate, there are things that they have to follow. It's set in rules. And if they don't do it, you build a solid case against them to sue them for not following whatever section that's in the Fair Credit Reporting Act. We're going to talk about Section 1681, and we're going to talk about 1681A. Gonna cover a little bit of that. But I just want to kind of go over some things with you. I'm gonna go over some terminologies with you in the beginning, so you can, when you hear these certain words, you know exactly what they mean. You have to know what they mean when you're going through these, so you can understand who they're specifically talking about, because you may think they're talking about this person, but they're actually talking about this person, which is going to is going to confuse you on what you need to do or what. So I'm going to go through this. I'm going to read certain things to you that I've highlighted that help you through this process. So you know the deal. Like, subscribe to the channel. I'm here to kind of give you the information that you need for you to go through this dispute process, right? Uh, and that's what's going to make this class a very powerful class. I'm going to break it down step by step, what you need to do, why you need to do it, go over this so you can understand what they need to do. So you know if you're doing it properly, putting your dispute letters together properly, following the process, and they just fail to do what they're supposed to do, you can go down to the courthouse, file a case against them under whatever section. I'm filing a case under 1681I because they didn't properly investigate the inaccurate information. Go to the court, probably cost you anywhere from $50 to $100, and then take them to court. But if you know your stuff and know it right, you can definitely get that stuff and sue them. Maybe get $1,000 or $2,000 for how many violations that they violated. So the biggest thing I would say is we don't do enough of this. Even though they make billions of dollars, we don't do enough of taking this to court to force them to be better at what they do. And because it is a monopoly, right? Which they don't let corporations do it because there's no competitive edge, but they allow the credit bureaus to do it, which I don't understand. They are a business, they are a corporation. So why do you not feel that? Why do they get an edge? Because there's no competitive, and they may say, well, you have three different bureaus, but those three different bureaus are operating under the same thing, and they all are not doing what they need to do. So why we don't have a government agency or an outside agency that we could also go to correct that have them provide accurate information, that we can go through them and get accurate information reporting to make it more. Because a lot of people, if they could switch from these bureaus to go to another credit reporting agency that is providing more accurate information, these companies will probably be more on getting the right information, and creditors will probably not pay them and go to the other bureaus that are providing accurate information where there's not a lot of complaints. Creditors know there's all type of inaccuracies, but they're stuck because they're just going to go on the basis of the credit bureau that they're a member of. So let's get into it. Try not to make this video too long. But people have been requesting this video, and I said I was going to do it. So here we go. Let's get it. So the first thing I want to do is go over terminology. So when you hear person, if you hear me say person, the person terms mean an individual, partnership, corporation, trust, estate, cooperative, associates, government, or government subdivisions or agencies or other entities. So if you hear that, real vague, I'm not vague, but it's real broad on that. The other thing you're going to hear, consumer reports. Consumer reports means any written or other communication of information by a consumer reporting agency bearing on the consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living which it used or expected to be used or collected in the whole or in part of the purpose of servicing as a factor in establishing consumers' eligibility for A, credit or insurance to be used primarily for personal, family, or household purposes, B, employment purposes, or C, any other purposes authorized under 1681B of the title. Right? Credit. Credit means credit and creditors. The term credit and creditors have the same meaning as in 1691A of this title, right? So we're going through, you know what that means. Consumer reporting agency. Okay, so you have consumer report and they have consumer reporting agency. The term consumer reporting agency means any person which, for monetary fees, dues, or on a cooperative non-profit basis regularly engages in whole or in part of the practice of assembling or evaluating consumers' credit information or other information on consumers for the purpose of furnishing consumer reports to third parties and which use any means of facilities of interstate commerce for the purpose of preparing or furnishing consumer reports. Reseller. The reseller means the consumer reporting agency. So when you hear reseller, it's talking about the consumer reporting agency, right? So when you hear those terminologies, that's what it means. Okay, that's what those terminologies mean. So 1681I is the procedure to in case of disputed accuracy. So you look at your credit report, you're looking and you're trying to find, you got some negative information that you're trying to get removed, but you're looking for inaccuracies, right? Again, I would tell you some of the most accurate data I'm seeing is if you go to each credit bureau or if you go to the annual credit reporting.com and then pull that report that is free now that you can do it every single week. Pull those reports. Some of these other third parties, sometimes they're not, remember, they're downloading information. So if their system downloaded correctly, they got different formats. So they're trying to download. So it may not be downloading correctly. So if you get to a point where you want to know, and I'm just saying that first report, now if you want to sign up for Identity IQ, but that first report, you need to pull from the big three or annualcreditreport.com, most accurate information, so you can determine if this stuff is reporting inaccurate, right? So we're just talking about the procedures. We're not looking at a credit report saying this is inaccurate, this is inaccurate. We're basically gonna cover the procedures, okay? So you identified something that's inaccurate, and now you want to, what are the procedures to dispute this inaccurate information? So in general, subject to subsection F and except to provide subsection G if the completeness or accuracy of any item of information contains in a consumer, we talked about who that is, file, right? That's who the credit bureaus keep at a consumer reporting agency, is disputed by the consumer and the consumer notifies the agency directly or indirectly through a reseller. We talked about who a reseller is. That's the credit reporting agency. Of such dispute, the agency shall free of charge conduct a reasonable investigation to determine whether the disputed information is inaccurate and record the current status of the disputed information. So when they say record, that's when they're going to apply disputed on your credit report. So if they don't put disputed, when you put that on there, right, that is a key sign that, for one, it's a violation. For two, it may turn around and say, have they received my dispute? So now, I used to tell people there's no need to send stuff certified, but now, because so many people are saying they're not even responding, you need to start sending your disputes in certified mail. So you know when they received it, so you have proof that this was mailed to them and they received it on this date. Why is that important? Let me continue to read. Disputed information, or delete the item from the file in accordance with paragraph 5 before the end of the 30-day period beginning on the date in which the agency received the notice of the dispute from the consumer or the reseller. So it's important, when they receive it is when that 30 days start. Okay, let me read something else to you, because a lot of times there's a confusion. The credit bureaus are extending. So saying, hey, we haven't got this information. Hey, if you haven't got it in 30 days, you're supposed to be deleting this information. There's only a couple reasons why they should be extending, right, your dispute. Except as provided in subsection C, the 30-day period described in subsection A may be extended for not more than 15 days if the consumer reporting agencies receive information from the consumer during the 30-day period that is relevant to the reinvestigation. Okay? So if you're not sending in any additional information during that 30-day period, they are supposed to be done with that in 30 days, right? I know COVID or whatever they put in, and they trying to use COVID as an extension. They have 30 days to get this done, right? Another thing, limitations on extension of period to reinvestigate. Subsection B shall not apply to reinvestigation in which, during a 30-day period described in subsection A, the information that is subject to the reinvestigation is found to be inaccurate or incomplete, or the consumer reporting aid determined that the information cannot be verified, right? So they can't be verified within that 30 days. They can't be extending it out to get it verified. If you can't verify within the 30-day period, you need to be deleting that information because it cannot be verified. All right. Another thing you need to understand, prompt notice of dispute to furnishers of information before the expiration of 5-day period beginning of the date in which the consumer reporting agency received notice of a dispute from the consumer or a reseller, which is a credit reporting agency, in accordance with the paragraph, the agency shall provide notification of the dispute to any person who provided any item information in dispute at the address and in the manner established the person. The notice shall include all relevant information regarding to the dispute. that the agency has received from the consumer. Okay, we're going to determine, because some people say, okay, they did not, uh, I sent in a dispute. I never got a response. It's 35 days. It's 37 days. It's 40 days. I never got uh, uh, a letter from the credit bureaus on the results of my disputes. Right. So first thing you should do is you need to look at your credit report and see if dispute has been entered. It's in dispute that on your credit report. That's a key indication that they may be trying to avoid your dispute. Now, some people say they didn't say, maybe they thought it was frivolous or whatever. So there's a process in that. And let me read that process. Determine the dispute is frivolous or irrelevant. Notwithstanding paragraph 1, the consumer reporting agency may terminate a reinvestigation of information disputed by a consumer under that paragraph if the agency reasonably determines that the dispute by the consumer is frivolous and irrelevant, including by reasons of a failure by the consumer to provide sufficient information to reinvestigate the disputed information. Now, upon making any determination in accordance with subsection A that a dispute is frivolous or irrelevant, a consumer reporting agency shall notify the consumer of such determination not later than 5 days after making such determination by mail or authorized by the consumer, meaning you authorize an email or other form text message for the purpose by any other means available to the agency, right? So don't be telling them in your dispute, I want a paper copy of my dispute. No email, no other forms of communication is accepted, right? So that's a clear determination on your dispute letter if you got to take it to the next level. So if they say, well, we sent you an email, I specifically said within my dispute letter, the only form of communication that is authorized is through mail. Okay? By doing that, you can eliminate, well, we emailed you or we went in your junk file, you never seen it, you deleted it. No, only form of communication is through email, right? That is the notice of determination if they feel like it's frivolous. Even when you go to disputes in, you should say the only form of of notifying of my disputes is through mail. That's the only communication I want to receive is through mail, right? And you should put that on your dispute letters, big bold. Only authorized communication is through mail. Okay. The other thing, treatment of inaccurate or unavailable information. So you got to use these words when you're putting your dispute letter together. Inaccurate, unavailable, right? Or and there's other things that we'll cover that you can use. This information is reported inaccurate, and because it's inaccurate, is unavailable to be disputing this information. You can use it in however form, but you can use those words, right? In general, after any reinvestigation under paragraph 1 of any information disputed, a consumer, an item of information is found to be inaccurate or incomplete or cannot be verified, the consumer reporting agency shall, 1, promptly delete the item of information from the file of the consumer or modify that the item of the information as appropriate based on the result of the information. And 2, promptly, listen what I'm telling you, promptly notify the furnisher of the information that the information has been modified or deleted from the file of the consumer reporting agency, right? So they gotta send that, and they gotta let the creditor know. So the creditor knows that that information has been deleted. They're not trying to reassert it because, first of all, they gotta notify you in 5 days. They're probably not gonna get to it. It's not gonna happen. So it's not reasserted, but they know they're reporting on Experian, TransUnion, Equifax. You had it deleted off Equifax and TransUnion, but Experian is still reporting it. Experian was notified that it was deleted off of those two accounts. Both of those credit bureaus notified Experian and said, we deleted this account because it could not be verified or it's inaccurate. So now you got to ask the question, Experian, under section 1681I, A, that the treatment of inaccurate and unavailable information, you were notified that this account was unverified, inaccurate. I am disputing this account. Why are you still reporting this account as accurate information on my credit report when two credit bureaus notified you, or one credit bureau notified both of y'all that this account was deleted because it was inaccurate and unverifiable? Why are you still reporting it as accurate information? Right? So let's continue on. Notice to consumer. Any information that has been deleted from a consumer file, right, to subsection A, is reasserted in a file, the consumer reporting agency shall notify consumer of a reassertion in writing no later than 5 business days after the reassertion, or if authorized by a consumer for the purpose of any or other means available to the agency. Meaning, you have to get it through the mail, and it's got to be within that 5 business days of the reassertion, right? If you got a reassertion and you never got anything from the credit bureaus, you should be disputing that item under that section. You were supposed to notify me within 5 business days by mail of this reassertion. This is a violation of 1681. Okay? Let's continue on. Notice of result of reinvestigation. A consumer reporting shall, and I'm not going to read every single thing on here. I'm just kind of hitting the key points. The consumer reporting agency shall provide a written notice to a consumer of the results of an reinvestigation under this subsection no later than 5 business days after the completion of the reinvestigation by mail, right? Which I already covered that. Let me go on through this. Follow any deletions of information which is found to be inaccurate or whose accurate cannot no longer be verified, or any notations as to disputed information. The consumer reporting agency shall, at the request of the consumer, furnish notification that this item has been deleted, a statement or a summary pursuant to subsection B or C to any person, right? Specifically designated by the consumer who has within 2 years prior thereto receiving a consumer report for employment purposes, or within 6-month period thereto receive a consumer report for any other purpose which contains the deletion or disputed information. Okay, there's a section called treatment of complaints to the report to Congress. Now, this is in general, the commission shall comply all complaints that have received that a file of a consumer that is maintained by the consumer reporting agency described in subsection 1681A. We're going to cover a couple of that of this title contains incomplete, inaccurate information with respect to which the consumer appears to have disputed the incompleteness or accuracy with the consumer reporting agency or otherwise utilize procedures provided by subsection A and B, transmit each such complaint to each credit reporting agency involved. Exclusion: complaints received or obtained by the Bureau uh, pursuant to its investigative authority under the Consumer Financial Protection Bureau Act of 2010 shall be subject to paragraph A. Listen, now let's get deep. Reporting agency's responsibility. Each consumer reporting agency described in 1681A of this title that receives a complaint transmitted by the Bureau shall review each such complaint to determine whether a legal obligation imposes on the consumer reporting agency under the subchapter, including each obligation imposed by the applicable appellate. Lord have mercy. You know I'm tongue tied. Applicable court or administrative orders, such has been met with respect to the subject matter of the complaint. B, provide reports on a regular basis to the Bureau regarding the determination of an action taken by the consumer reporting agency, if any, in connection with the review of such complaints. So what I'm trying to say to you is, when you file these complaints, right, you have to understand the regulation. Quit just listening to what people tell you and don't go into the regulation. And that's why some people, they're reviewing this for, is it any legal basis for the complaint? So you can't just say try to use, for instance, you can't use Metro 2 as a complaint for a legal basis for something to get deleted, when Metro 2 is, you can't sue under Metro 2. You following me? So when they look at these complaints, they're looking at what are the legal basis of the complaint. Does it fall under one of the chapters, 609, 1681I? Does it fall up under those? Did we follow those procedures, right, to properly investigate? Because they're going to say we did a reasonable investigation. But did they notify me of the investigation? That's why I say you want to send those certified letters. I have proof that you received this letter on this date. Five business days after that, you never put that this item was in dispute. You never notified me that this item was in dispute, right? Or you received this information on this date. I never received it was never in dispute. I never seen anything that was emailed to me. And you can also say, because I'm telling you, don't put that in, don't let them email you. Put nothing was never mailed to me notifying me of the results of the investigation. Okay? I promptly said no emails in my letter. I have my letters. This is the certified letter receipt. This is the receipt that showed that you received it. I never received any results from the investigation. I never received, which is another violation, that these items were in dispute. So those are the things that they look for when you're filing a financial consumer protection complaint. Now, again, if you're filing stuff that somebody said under Metro 2, you wasting your time. It's not illegal. You can't sue under that. So they just going to brush it to the side. You don't even have no legal basis for this complaint. Right? So those are the things you definitely need to understand. Like when you're filing these complaints, that's why some people get so upset because, and I don't see the complaints, but they're filing complaints that are not legal basis complaint under whatever section of the Fair Credit Reporting Act. And that's what you need to base your complaints on. When you send it, you're going to say, I submitted a dispute on this date. You're going to upload the file. This is the receipt of this is the receipt that I sent it certified mail. This is the copy, the date they received it. I never received that a result from the investigation. Here is a couple things I deleted. Here is my credit report. It shows that none of these, this is dated this date, that none of these items were placed in dispute. That's a violation, right? Those are the complaints you need to see, because those credit bureaus say, hey, why was this not investigated? Why was this? And then maybe when you send in your method of verification, you'll probably get some deletions based on that they've already made some violations. Okay? So let's continue on. Hopefully I'm explaining this stuff and breaking it down for y'all so you get a better understanding. Action required under receiving notice of a dispute. The reseller receives notice from a consumer of a dispute concerning the incompleteness or accuracy of any item of information contained in the consumer report. On such consumer produces by the reseller shall within 5 days receive the notice and free of charge. If the reseller determines that the item of information is incomplete or inaccurate as a result of the act of or omission of the reseller, convey this notice of the disputed together with all relevant information provided by the consumer, listen, to each consumer reporting agency that provided the reseller with the information that is subject of the dispute, using an address or a notification specified by the consumer reporting agency for such notification, okay, or notice. So what I'm telling you again, I just read it to you. This is under section 2A. It says 1681I that if a reseller determines that an item, again, has been deleted, they have to report that to the other credit reporting agencies. Remember, these agencies, I don't hear nobody tell you, are cross-communicating information. That's why they're telling them that you have to send that information to the other credit reporting agencies, right? For notice, right? So you have to understand, and that's why when you do your if you get it deleted off a couple of them and you do your method of verification, because Experian, you need to say you were notified by TransUnion and Equifax under 1681I that as a reseller, you were responsible for notifying the credit reporting agencies of the deletions, the modifications of this account. So you were notified that this account was deleted. So please provide your method of verification on how you prove that this count was complete, accurate, and verifiable. And that's your method of verification letter, right? So you got to come back at them with, like, you know what has to happen under these regulations, right? That's why it's important. Quit doing all these, like my thumbnail. Quit trying to do all these tricks and gimmicks to get stuff. Follow the rules. They right there for you, right? We just don't follow them, right? Responsibility of consumer reporting agencies to notify consumer through resellers. Upon the completion of a reinvestigation under this section of a dispute concerning the completeness or accuracy of any information in the file of a consumer by the consumer reporting agency that received notice of that dispute from a reseller under paragraph 2, the notice by the consumer reporting agency under paragraph 6, 7, 8 of subsection A shall be provided to the reseller in lieu of the consumer, and B, the reseller shall immediately reconvey such notice to the consumer, including any notice of deletion by phone in the manner required under under paragraph 8A. Okay? So there is a section in here for disputed process for veterans on medical debt. I'm not going to go into that. If anybody wants to know more about that, but I got extra stuff over here. So this is what you want to. Listen. That's the ticket right there, right? Follow the process. You're going to dispute. You're going to dispute an item, and maybe I'll go through another class. What I do can go through another class where I find a dispute and walk y'all through the process on how I'm going to dispute that item, right? Using their, using their laws from whatever section that I'm going to do, and then I can show you how to walk that process through, right? So you can get the deletions that you want. It's all about following the process. If you don't follow the process through, the credit bureau is like, they ain't even following the process. They don't even know the process. They ain't filing the complaint. Because if you're filing the complaint of the Metro 2, Metro 2 says this because I know Metro 2 and I know how you can use it to help get deletions, but you can't use it as a legal basis to get something or file a complaint. You need to file a legal basis, right? So if you want to know more, there's much more to this 1681I. If I didn't make anything clear to you, please get with me. We could talk more about it. But if you have any questions, you know the deal. I'm going to cover some brief things about 1681A. Listen, 1681A is a lot of definitions and things that Congress is supposed to be doing and how they kind of govern Title 15, 1681A on certain things in the credit bureau. And the 1681A is in the Fair Credit Reporting Act. So yes, you can use 1681I if they're not doing certain things. But a lot of 1681 comes back from study required. What is the same terminology that's in, for example, it says the extent of which requiring additional points of such identifying information to match would, let me go back up further. So in general, the commission shall conduct a study to improve the operation of the Fair Credit Reporting Act, right? Which is Title 15 USC 1681. The area for studies is conducting the study under paragraph 1. The commission shall review the efficiency of increasing the number of points of identifying information that a credit reporting agency is required to match to ensure that a consumer is the correct individual to whom the consumer reporting agency relates before releasing a consumer report to a user includes. So it's just telling the information that the credit reporting agency must do before releasing information. To extend in which requires additional points in such identifying information to match would enhance the accuracy of credit reporting, combat the provisions of inaccurate consumer reports to users, to extend to which requiring exact matches for the first and last name, social security number, and address and zip code of the consumer report enhance the likelihood of increasing credit reporting accuracies, right? The effect of allowing consumer reporting agencies to use partial match of a social security number and a name recognition software on the accuracy of a credit report. So it's telling them they can use software to, even if they're using a partial match, to identify you as the individual, right? Uh, it says required notification to consumers when negative information has been added to their credit report include potential impact on such notification, the ability of a consumer to identify errors, the credit report, and the potential impact of such notifications on the ability of a consumer to remove fraudulent information from a credit report. The effect of requiring that a consumer who has experienced an adverse action based on a credit report receives a copy of the same credit report that the creditor relied on in taking the adverse action. So remember, uh, remember that they have to provide the same credit report that they gave to the creditor when the creditor made the decision to give you an adverse action. That is what you can do. So you can send in what credit file or what did you send the credit bureau, the creditor, what information did you send the creditor. I need to know that information, right? So to and this is something that I want to dig into because a lot of time creditors don't want to give you the report that the credit bureaus, and under section 1681A, the effects required, it says again, the potential impact of such information, the ability of consumers to identify errors on their credit report, and the potential impact of such notifications on the ability of a consumer to remove fraudulent information from their credit report, the impact of requiring that a consumer who has experienced an adverse action based on a credit report receives a copy of the same credit report that the creditor replied on in taking the adverse action. So they have to give you the same credit report because what you see when you're doing on third party is not the same credit report that they're getting. So under this section 1681, they must give you a copy of it. The effects of requiring a consumer who has experienced an adverse action based on a credit report receives a copy of the same credit report that the creditor replied on in taking the adverse action. So the credit bureaus must give you that same credit report, and you can request it, right? So let's talk about a couple of terms. The term investigative, the credit reporting agency means a consumer report or portion thereof in which the information on a consumer's character, and I went over this, a consumer's character or mode of living is obtained through personal interviews with neighbors, friends, associates of the consumer reporting on or with others with whom he or she has acquainted it or who may have not knowledge concerning any such item of information. However, such information shall not include specific factual information on a consumer report contained directly from a creditor of the consumer or from a consumer reporting agency which information was obtained directly from the creditor of the consumer or from the consumer. Right. So a lot of these in section 681 is going to give you the terms. What is the term of a file? What's the term of medical information? What's the term of adverse action? What's the term, let me go to the next page. Uh, what's the term of what a creditor is? Uh, so a lot of this, what is insurance? Firm offering of credit with insurance. So 1681 kind of breaks a lot of that down. And maybe some things in here. That section, the first section I read, is a section that's very powerful that you need to be using. If you get, they say you get a free credit report, right? Yes, but is this the credit report you sent the creditor? Under 1681, I can be issued and get a copy of the same credit reports you sent the creditor. So it's all about knowing what's in front of you in the laws, right? And if you understand that, you will come out way better improving your credit. So I'm gonna give some more of these classes. This week it's gonna be about classes. We're gonna go over 609. So people quit talking about these 609, and I'm gonna break down what 609 really means. I'm gonna help you out on that aspect. We're gonna talk about 1681B, permissible purpose of a consumer report. So this week we're just gonna break down classes, right? I think sometimes we skip over the classes and we go, but hopefully this class was very informative to you, and hopefully I gave you some good information. If I stumbled over something, man, just just let me know. But hey, this is all about keeping it real with y'all, and this is the best credit repair channel, man, no doubt, because I'm gonna bring you the real information, no gimmicks, no tricks, none of that, because that's how you're gonna either get paid or get the results that you want. So if you got any questions, email me. I do have my master dispute package back online. I need to get with my dude about my website, because we still working on it, and so I need to reach out to him today, figure out what's going on. But trying to get this website up and going. But if you need that master dispute package, if this is information, like I put all this information in my master dispute package so you can have it readily available along with everything else. Information is power. So if you want that master dispute package, you definitely can get it. Now that I'm back home, I'm gonna be working on my book with all this information in it. It's got a lot of great knowledge, hyperlinks, everything. So just to take you to some more information. So if you have any questions, please get the package. It's definitely very good. $70 for the package. Ain't no head, no none of that. $70 for the package. But I guarantee you get more information out of that. This is a way better investment than paying somebody $2,500 for information, and a lot of that information you can't even be using or sue on this. So keeping it real with you. And if you got any questions, email me. You know the deal. My email's in the description. You want the package, email me that you want the master dispute package. I'll send you a PayPal invoice and send it right over to you. I appreciate your time, and I'm out.